Good day, everyone. My name is Marjorie Almar, and I will be discussing about artificial person or juridical person and partnership by Estoppel. So first, let's start with artificial person or juridical person, which can also be called as a legal person or a juristic person. To better understand what a juridical person is, let us compare it with a natural person or a human being. A natural person came out from his or her mother, while a juristic person is a product out from the idea of a natural person. Next, a natural person has to be registered under the Philippine Statistic Authority with information such as his name, birth date, mother's name, father's name, and such. While on the other hand, as an artificial person, it must also be registered under the Securities and Exchange Commission. And by the time that it is already registered, we can now say that a company has born legally. Next, a natural person has a mind, eyes, feet, and etc. Same with juristic person, which also has mind, eyes, hands, feet, and etc. But the only difference is that there are many minds, eyes, hands, and feet that works together to reach one goal. Next, both natural and artificial person has liability, obligations, and responsibility in law that must be followed to avoid conflicts. Lastly, both can also be sued, and to be sued. The only thing is that as a juristic person, all the liabilities and all the obligations will be covered by the or will be under the company's name and not the people who are working or who are under a company. Being a juristic person safeguards or protects the member of a company from personal liability. So next is partnership by Estoppel. In Article 1769 of the Civil Code of the Philippines, it says there that there are rules to apply in determining if a partnership exists, except of um, what is provided by Article 1825, which says that persons who are not partners to each other are not partners as to third party, meaning that if for A and B they are not partners, then for C, D, and F they also assume that there is no partnership has formed between A and B. But what if a misrepresentation happened wherein a person who is not an actual partner present himself as a partner? In able to understand or in able to answer that, we have to know what a partnership by Stoppel is and know how it arises. So partnership by Stoppel is formed when a person by his words or conduct create an impression in the mind of a third party that he or she is an actual partner of a firm or company when he is actually not. And it may arise in form of um, Stoppel in pies, where it is by statement, silence, or omission. This means that it can be direct or indirect. Direct in a sense that for you example, you personally claim that you are a partner, that you are partners with someone, and then indirect um when someone else claim you to be his or her partner, and then by knowing or upon knowing about the claim or the declaration of of, of someone, you kept in silence, you did not do anything to correct the declaration. Next is Estoppel by deed. that is viewed in any document, meaning that there is a document that supports a partnership through though you may not know about it. Last is by latches. Um, by pass it is by passage of time. Um, we have what we call statute of limitation, which is the prescriptive or the prescribed period to sue a person. So as a victim or of a claimed partnership, you have those years to sue that person. Next, um how if a person present himself as a partner in an existing partnership? um There can be two factors that we must consider. And first, if all partners in an existing partnership gave consent to the misrepresentation. Of course, the liability will go against the person who misrepresent himself and all the partners who gave consent to that misrepresentation. Second, if not all partners consent to misrepresentation. Oh, in here, only those partners who consented, the person who misrepresented himself will be liable together with that person itself or the person himself. Those partners who did not give their consent or may not know about the misrepresentation will be free from the liability to the third party. Now, what if a misrepresentation happened with a non-existing partnership? For example, A and B are not really partners. They are not bound in any form of partnership. But B would like to have a business and assume that A is his partner. And then B asks C, the third party, to join his assumed partnership with A. Then when A learned about the declaration of B being him as his partner, he did not do anything to correct the misrepresentation. So we can say that A and B are partners by Stoppel, and both of them will be liable for the misrepresentation. And also, A can be called as a partner by holding out because, as of the definition of partner by holding out, it is when A was called out and declared by B as a partner but did not react or contradict even after knowing such declaration. Now, take note that a partner by Stoppel does not participate in management of firm. He doesn't also not share profit and loss, do not contribute capital or anything to the partnership, but he has a limited liability to all the damages or to all the um the things that he have done to the third party or the mistakes and the damages that caused by um by the misrepresentation. That's all. Thank you.